When two trademarks are confusingly similar to people who buy products or services, there is a likelihood of confusion. The basic standard comes from a case called In Re EI DuPont de Nemours and Company. This is the federal standard. Each federal circuit in the U.S. has a variation of this case and its 13 factors. They all essentially boil down to one question. Is there a reasonable likelihood of confusion as to the source or origin of goods in the relevant marketplace? In other words, will consumers be confused by the two brands? Let's meet VJ. VJ is a brewer in San Francisco, California. In 2005, VJ began brewing and selling beer under the brand name Hippie Hoppy. VJ filed a trademark for Hippie Hoppy in Class 32 for the sale of certain goods, in this case beer, in 2006, and he sells his beer in both California and Oregon. Now let's meet Ron. Ron is a brewer in Orlando, Florida. Ron began brewing beer in 2017 under the brand Hip Hops. Ron never looked into trademarking his brand. The 2020 Brewfest in Golden, Colorado rolled around, and Ron and VJ saw each other's beer at the festival. VJ immediately went home after the festival, and Ron went back to Florida. When VJ got home, he called his lawyer and told his lawyer about Ron's brand, Hip Hops. He also told his lawyer that some people at the festival thought that the Hip Hops beer was an affiliate of his company, Hippie Hoppy. VJ's lawyer looked into Hip Hops and discovered that Ron is trying to get a trademark too. VJ's lawyer gives VJ some options. 1, he can send a cease and desist letter and demand they stop using the brand. Or 2, they can file an opposition to Ron's trademark. Or 3, they can just sue Ron in federal court. Ron flew home, and he immediately had filed a trademark application on his own. Ron called a trademark lawyer as well, and Ron's trademark lawyer gave Ron some options after seeing the two marks. His lawyer said, "Hey, you can reach out to VJ right away and see if VJ will agree to let you keep using the mark, because VJ had the mark first and was using it in commerce first. Maybe you can get a coexistence agreement. 2, you can change your brand right away. Or 3, you could ignore the fact that the two brands are the same, but realize that VJ could sue you sometime at any time in the future. And if Ron knows about VJ's mark, he could owe VJ a lot of money, including attorney's fees, for something called willful infringement." Likelihood of confusion is confusing. You might see likelihood of confusion in one of 4 common cases. The first common case is during registration. Let's say you file a trademark and the USPTO issues something called an office action, rejecting the trademark application because they claim there is a likelihood of confusion with another registered trademark, and this may confuse customers. Well, you now have 6 months to respond to the rejection with the reason why your trademark would not be confusingly similar to the existing registered marks. Usually you get 2 chances to change the USPTO examiner's mind. The second common case is the opposite side of the first case. In this second common case, you already have a registered trademark, and someone else is attempting to register a trademark that might be confusingly similar to your trademark. You have a few options in this case. You can either 1, do nothing and hope the other side drops the application, or 2, if you can see they're using the trademark already to sell products or services, then they might be infringing. And this leads us to the third common case. Someone else is potentially using your trademark and infringing on your brand. It's time to call your trademark lawyer and figure out what kind of letter to send. Should the letter be a request for coexistence or a cease and desist letter? While it sounds like there's an easy answer, it's not always the case. For example, even if your trademark was registered first, the potential infringer might have been using the confusing mark to sell things before you did, and they might be able to cancel your trademark when they get your letter. So it's always a good idea to talk to a trademark lawyer before making a decision or taking any action which could put you in a worse position. Dunlap Bennett and Ludwig manages thousands of trademarks for everyone from small business owners, large global companies, to even the federal government. With experienced former USPTO examiners and decades of trademark experience, DBL can take much of the burden off your back, giving you the information you need to make an informed business decision. Ask us about our trademark monitoring solutions and global trademark filing options. For more information, email trademarks@dbllawyers.com, visit our website at www.dbllawyers.com, or call us at 855-777-7319.